I have a new travel warning for green card holders. If you have a 10-year green card or a 2-year green card, listen up. The travel warning is coming directly from the American Immigration Lawyers Association, and they say that they have become aware of the fact that Customs has changed its practice as it relates to how it treats green card holders who are in removal or deportation proceedings. They are now being detained by either Customs or ICE when they're trying to come back into the United States. These are individuals, guys, who have a notice to appear in immigration court. Yes, green card holders who are going through removal. It also includes those of you who had applied to remove the conditions on your green card, the 2-year green card, and that process didn't work out for you. Your I-751 was denied, yet you were able to get a stamp in your passport to allow you to travel outside of the United States. You are also at risk of being detained upon entry into the United States. So it is advisable at this time that green card holders who are also in removal proceedings to not travel internationally. Guys, I'm covering all things related to the changes under this new Trump administration with immigration. Follow for more.
Let's talk about green card holders and travel. Recently, it has come to my attention that there are green card holders who are traveling, which means that they're traveling internationally, and when they try to re-enter the US, they're not allowed to re-enter. And of course, there is panic. Everyone is wondering, what does this mean? Does this mean that green card holders are no longer able to travel and return to the US? Does this mean that green card holders are being deported from the US? The answer is no. And let me explain why. As you know, I talk about this a lot. If you follow me, you know this. I'm attorney Byers of the Byers firm. I've been practicing immigration for 19 years. I have always told green card holders that you can lose your green card or holder status. If you commit certain crimes as a green card holder, you are deportable. Certain crimes, not all crimes. If you abandon your status, if you are out of the US for more than 6 months at a time, and you have not applied for a re-entry permit to tell immigration that you are not abandoning your status, immigration may assume that you've abandoned your status and take your green card away. If you have obtained your green card under fraudulent purposes, you either misrepresented or you lied or you committed fraud and your green card was approved, your green card can be taken back from you. You have voted in elections, right? That is an offense. Green card holders cannot vote in elections. Green card holders cannot represent that they are a U.S. citizen in order to obtain benefits. That's also an issue. So you can lose your green card holder status. I have discovered that individuals at the airport who are having issues returning to the U.S. after international travel have a criminal history, and they're currently in deportation proceedings because of this criminal history. And maybe what is happening at the airport is immigration has decided to do an expedited removal because they're going to be taking the green card back anyway, and they're just doing it quicker rather than later. The other issue is I've also heard that some conditional green card holders are having issues when they return. A conditional green card holder is someone that received their green card through marriage, and at the time of the approval, they have not been married for more than 2 years. So you have a 2-year green card. Now, if you come through the airport and immigration is questioning you at the airport, which they're allowed to do, and they discover they've received enough information from you to make the determination that your marriage was not a genuine one, it was a fake marriage to procure a green card, then that's misrepresentation and fraud. And of course, there are consequences for that. So I want to let everyone know that if you're a green card holder, you have not abandoned your status, you've not committed criminal offenses that would make you deportable, you did not obtain your green card fraudulently, you did everything legally, you live in the US, you've not abandoned your status, you are here more than you are gone, no trips for more than 6 months, you have a clean record, you are doing a great job in maintaining your green card, and you will be able to re-enter the US. However, if you fall into any of those categories, please know that you may have issues at the airport. I hope I was able to give you good information so that you now know what's going on. If you are in the U.S. on your visa, could be a visitor visa or a work visa, are you deportable? The answer is simple. You are here lawfully, and so you are not deportable. Hi everyone, Attorney Byers here with the Byers Firm. So this is a question that of course is very, very important. Everyone is concerned. The individuals who are a target of ICE are individuals who are here unlawfully. So if you're here on a work visa, you are here lawfully, you are here with permission. If you are here on a visitor's visa, a student visa, etc., you are here lawfully as long as you are following the requirements of that visa. Now, of course, there is a recent executive order where the U.S. is going to be reviewing all visa programs. And once they make that review, once they complete their review of their visa programs, there may be issues that occur that will impact visa holders. But we do not know what those things will be. There may be a travel ban in the future. At the moment, there is no travel ban. So for those of you who are here on your visa, you are here lawfully, you're not deportable as long as you are in compliance with the requirements of that visa. So let's talk about special immigrant juvenile status. Hi everyone, Attorney Byers with the Byers Firm. So what is special immigrant juvenile status? This is reserved for individuals who are in the U.S. They are for children who are under 21. They're undocumented, and unfortunately, they have been neglected, abused, and abandoned by their parent, and they have gone through the state court, juvenile court system, and received an order that shows that these things have been happening to them. Immigration will then allow that child who is under 21, unmarried, with their juvenile court order to apply for lawful permanent resident in the U.S. Presently, I do not see any executive orders or any policy changes that would prevent anyone from applying for special immigrant juvenile status if they meet those requirements. So that is good news. Everyone, Attorney Byers with the Byers Firm. So what is special immigrant juvenile status? This is reserved for individuals who are in the U.S. They are for children who are under 21. They're undocumented. And unfortunately, they have been neglected, abused, and abandoned by their parent, and they have gone through the state court, juvenile court system, and received an order that shows that these things have been happening to them. Immigration will then allow that child who is under 21, unmarried, with their juvenile court order to apply for lawful permanent resident in the U.S. Presently, I do not see any executive orders or any policy changes that would prevent anyone from applying for special immigrant juvenile status if they meet those requirements. So that is good news.